All right.
Okay, so hi everybody. I'm Peter Schwartz. I'm the director of the Bioethics and Subject Advocacy Program of the Indiana CTSI, and we hold these TREATS talks, which are Translational Research Ethics Applied Topics courses. They're aimed to provide shortish introductions to ethical issues in conducting translational research, usually that arise out of a previous consult we've had or a question we've had. Not always. This one does arise out of a previous question that we've had, actually repeatedly in different contexts. And our presenter today is Jane Hartsock, who is a visiting assistant professor here at IUPUI in the Medical Humanities and Health Studies program. She has a JD and an extensive background in health law and now in medical humanities. She is also our newest faculty member in the Bioethics Subject Advocacy Program, and so she, like the rest of us, are available for consultations on these and other issues in the future, and these TREATS talks are meant to provide an introduction and also an opportunity for people who are doing research who may have questions to not only learn, but also to call us if they have questions. So with that, without further ado, I'll turn it over to Professor Hartsock.
Thank you. Hello, I am Jane Hartsock, and that was a lovely introduction. I don't feel like I need to add really anything to it, so we thought we could kind of move on. So today we are going to be talking about I think I initially titled this Problems of Reconsent, and I thought, let's just be more friendly about it and call it Issues of Reconsent in Pediatric Biobanking. These things don't necessarily have to be problems. It can just be a sort of way of looking at the issue. So that's what we're going to talk about today. And the particular issue that is under examination is under what circumstances is a researcher required to obtain the reconsent of a research participant who was enrolled in research as a child and has since obtained the age of majority. So hello, Mary. So that's what we're going to be talking about today, and I like to kind of outline the issue at the front so we have some boundaries on the conversation, because there are lots of issues of reconsent that may pertain to adults, but we're going to talk about this within the context primarily of pediatric biobanking and children. So we're going to do that through three sort of objectives. We're going to talk about we're going to get a kind of overview of biobanking within the pediatric context. What is it and how is it sort of different? We're going to talk about the limits of the existing regulations as to reconsent. What I mean by limits is really the way in which there is an absence of commentary in the regulations on this issue that leaves us sort of without a whole lot of guidance as to what to do. And then we're going to propose a framework for reconsent, for the examination of reconsent versus when waivers would be appropriate. I had originally kind of a fourth objective of examining future issues that might come up, particularly with respect to the new common rule. But I think it makes more sense to just sort of drop the comments in as we're going along, and you can create the contrast as we sort of examine this issue. So biobanks, for anybody who doesn't know, there's a nice, clean definition of that by Harrell and Rothstein, that biobanks are repositories that assemble, store, and manage collections of human specimens and related data used to elucidate subtle connections between genetics and health, identify ways in which genetic variants contribute to illness, and obtain powerful research results through large sample sizes. So biobanks in the United States can be disease-specific or not disease-specific. They take a lot of different forms. NIH is working right now to create a biobank for health-related data pertaining to veterans, which seems like a very interesting and useful project. There are also cancer-related biobanks, and many of those involve pediatric research. So biobanks can store any kind of data, really, any kind of specimen, from plasma to genomic data. They can be private or academic, so they can take a lot of different forms, but most are academic, and most get their samples from forming relationships with hospitals, either private hospitals or academic hospitals, and then those samples come by way of patients at those hospitals. So there are more than 630 biobanks in the United States, and that number is growing, particularly in light of the Precision Medicine Initiative directed by NIH. Thanks, Obama. Almost all biobanks require IRB approval before researchers can access specimen. And when we talk about IRB approval, as most people have probably caught on by now, this ends up boiling down usually into issues of consent. How do we obtain consent and properly advise people of what they are agreeing to do and what may happen with their information if they participate in research? So biobanking scenarios can take on sort of four primary forms. I've got pediatric in parentheses here because this is really true irrespective of whether you have an adult or a child, but they can be actively collecting disease specimens specific to, for specific information. So active meaning the person is, the participant is being used specifically for research. And then biobanks actively collecting samples and information from all persons without regard to disease status. So not necessarily looking for a specific disease, but maybe looking for more general connections or information. Biobanks passively collecting disease-specific samples. So this would be biobanks that collect information incidental to care that's otherwise being provided at the hospital. So if you go in for a blood pregnancy test and the blood that is used for the pregnancy test is then retained for analysis of other things. So those models are the same in children and adults. The last two do not presently count as human subject research, which makes the informed consent and reconsent issues sort of moot. But the new rule would arguably include passive samples, which is one of the reasons it's not very popular. So if it does include passive samples, then consent becomes an issue there. And oftentimes passive samples can become, can require consent if they become de-identified. And so in that case, you would be required to obtain consent of the participants. So, so that recategorization results, the de-identification, the re-identification of the samples results in a recategorization of the research into human subject research, which requires consent. All right, so this is our current common rule in the context of consent for children, and this is just the initial consent. So this is not particular as to reconsent. And what this really does is follow the familiar assent permission format that we see a lot in pediatric care and treatment, and uses that also for research. It incorporates by reference provisions of the common rule on traditional informed consent as it relates to adults in order to obtain the permission, to set the standard for obtaining permission of the parents. So the informed consent process for the parents must include disclosures of pertinent information under Section 116 of 45 CFR 46, and the provisions of waiver must follow that format as well. And so, briefly for review, the waiver provisions, in order to obtain a waiver for obtaining consent, you must have a study that involves minimal risk to the participant. The waiver will not adversely affect the rights of the participant. The research could not practicably be carried out without the waiver, and we can talk a little bit about that later. And subjects will be provided a debriefing after their participation, or there will be some explanation for why they cannot reasonably be provided that debriefing. So what's important here in number 3 is that this provision is silent on the issue of reconsent, which is actually, kind of a fairly substantial oversight in light of the nature of pediatric research generally. So the reconsent issue is an issue not just in biobanking, but you could imagine that it might be an issue in other kinds of pediatric research. So, so it is a little bit of an oversight. So why is reconsent an issue in pediatric biobanking? It can be an issue in adult biobanking as well, but it's important to look at how pediatric biobanking is distinct from other forms of research, particularly in the adult context. And I'm sorry for the formatting on this. I've tried to list the sources at the bottom so people can read the articles themselves, and I think in the transfer up to the big board, it's kind of gotten smooshed. But so there are some temporal concerns with pediatric research. Pediatric research may take place over a longer period of time, and it's more likely, obviously, to bridge the span between adolescence and adulthood, which is the period of time when you would need to reconsent. You can imagine that there might be physical harm with respect to pediatric research, so it's possible that the information that is obtained as a result of biobanking, as a result of forming those connections between and those analysis of specimens might result in changes to clinical practice as to that particular participant. There may be psychological harm that results from the question of whether or not to provide findings of the research to the participant, economic harm as it relates to the adverse effects on employment if a participant has a specific diagnosis or condition, and the loss of privacy, which is always an issue in any kind of research, that the information could be released without consent. And there seems to be a sort of particular concern with that as it relates to biobanking, almost a kind of dystopian novel type idea that all of your information is going to be contained in these large computers, which would be susceptible to infiltration by whoever, and we where's Tom Clancy when you need him, I guess. So this issue of loss of privacy is a concern for people. And so looking at these generally, you might think of them as falling really into two categories. The first would be the temporal concerns that Brothers raises, that has to do with the fact that pediatric research might be longer term, and the reconsent issue presents as a result of that longer term research, where it bridges this gap between maybe infancy to adulthood or adolescence to adulthood, these very long periods of time, important periods of time. And then the other items on this list clearly could affect adults too. But we have to keep in mind that when an adult consents to participate in research, they personally accept these risks as part of the potential harm. And when a child is involved in research, the parent initially accepts these risks on behalf of the child. And even assuming the parent is acting thoughtfully and morally, we can understand that as the child grows, they may have a different assessment of the risk they're willing to undertake and reevaluate that as an adult. And so we have to ask ourselves as researchers whether they should be given an opportunity to reevaluate that risk for themselves upon adulthood. And so it is the nature of the change in age that makes the sort of the physical harm, the psychological harm, the economic harm, the privacy issues particularly relevant to reconsent in pediatric biobanking. So, that's too bad. So this is IU's SOP as it relates to reconsent. So Indiana University has its own SOP specifically as to the reconsent issue. They have dealt with it affirmatively, recognized it as a potential issue, and they have guidelines on this. And I'm not going to read them, but basically that the IRB could approve a waiver of reconsent, but that the subject should be given an opportunity to reconsent. Investigators should seek them out, and that the research should, if the research does not involve any ongoing interactions or interventions with the subject, but continues to meet the regulatory definition of human subject research, then it would be necessary for investigators to seek and obtain the legally effective informed consent of now adult subjects. So very pro-consent, putting quite a bit of obligation on the part of researchers to get that consent once children become adults. It should be noted that this language is actually the exact language, pretty much the exact language, taken from the Office for Human Research Protection's website under their frequently asked questions section. So a frequently asked question of the Office for Human Research Protections was, how do we handle reconsent? And they have suggested that it follow this format on their frequently asked questions, but have not amended their rule to formally incorporate this into the common rule. So not surprisingly, a lot of biobanks have adopted exactly this language, just as IU has. And so when you look to the SOPs of other biobanks, other academic biobanks in particular, you will often see what is essentially a sort of cut and paste from the frequently asked sections site. So to the extent that Indiana University is concerned that their policies run afoul of anything, they don't. But they do place quite a bit of burden on the researcher. And so we might ask whether there's a way to balance this. So what does it take to reconsent people as adults? Is it really that hard? Is it really that different from just the general consent issue that exists in adult biobanking or adult research? And I guess I would just submit the answer is yes, it is different. Basically, any research that is going to carry through from any under 18 age group into adulthood will then necessarily have a two-part consent process just incorporated into the research. And this makes the consent process of pediatric research more expensive than adult research. And it does have the potential to discourage overall pediatric research, which is particularly true for research that might involve smaller programs or fewer investigators, fewer subjects, or a larger developmental spectrum, meaning that the research involves a number of children who are maybe ages birth through 16 or something like that, where the consent issues might be different along the line. So, so what the risk here is that we might find ourselves in a situation where we're actually discouraging pediatric research because we're making it expensive as part of this two consent process. So there are also pragmatic concerns here that are actually probably the bigger issue. So really just being able to get a hold of people once they turn 18. So like getting a call back, getting a signed return. I kind of feel like this captures it fairly well. So anybody who is listening who is the parent of a teenager, trying to get a call back from that person if you are not really their priority. So tracking down the participants can be difficult. There's a kind of progression in research where the more face-to-face interaction the researcher has, the more involved the participant is in the study, the easier it's going to be to get that consent. If they're still regularly seeing you, you put the consent down maybe in front of them at one of their appointments. But if the research relationship is more distant to that, it can be more difficult. So, and then even with current contact information, it can be difficult to get a response from an 18 or 19-year-old who is out on their own. So even if you have a medical record with current and up-to-date information, again, just getting the person to respond can be quite difficult. And one article I thought captured this well, written by Rush, noted that a 2-year follow-up as part of an epidemiological study demonstrated that a majority of 2-year follow-up, a majority of participants did not respond to mail correspondence, and telephone follow-up was resource intensive. The allocation of additional resources required for reconsenting must be considered, as these resources could otherwise be diverted to improving core biobanking operations. So the alternative is to think of waivers in a more permissive way. We can have opt-out notifications, which technically are not consent, but for example, the Vanderbilt University uses an opt-out format for their biobanking, where people can sign a form saying they don't want their samples to be used in biobanking. But the rules, or we could think of expanding waivers on a case-by-case basis that includes considerations of the age of the participant at the time of the initial consent. So does it really make sense for us to be getting assent and permission when a participant is 16 and then tracking them down to get their written consent again maybe 18 months later when they turn 18, that there maybe we should drop the age within which we allow waivers for reconsent upon the age of majority. So the other question you might want to think about is whether there's even ongoing collection. So if you've collected the specimen in the past and you're still doing research on it, it may have implications in a sort of abstract way, but should we really be going back and reconsenting people if we aren't really even continuing to collect data from them? We're still sort of examining it. Also issues of EMR linkages. There are ways to de-identify the data for the researcher while still allowing the provider to put information in that the researcher has access to. And then this inquiry of practicability. So what's the how are we going to define practicable? If we want to expand waivers, we might want to look to whether or not we're really being thoughtful and logical about the costs and the realistic alternatives to doing that. So what does practicable mean? There are a few definitions around, but I like this particular one where something is impracticable if the effort to contact the participants would prevent the investigators from attaining important research aims. And so prevent there should be read sort of broadly, not just literally prevent, as in make it impossible, but discourage, meaningfully discourage, make it considerably more expensive, or have a truly negative impact on the ability to obtain data. So one of the ways that the rule seems to handle the practicability issue with waivers is to suggest that waivers should be rare. So they seem to have a quantitative understanding of waivers, that they should not be used very often. And then the new common rule says they should be extremely rare. And while it doesn't spell out a sort of audit trigger kind of framework, you can imagine it easily going into that, where they really are asking researchers to keep track of how many waivers they request and receive as a sign of whether or not those waivers are being handed out judiciously. So I would suggest that the emphasis on quantity is a poor metric for whether waivers are appropriate. So waivers should be granted where they are appropriate, where research profiles match the criteria for granting them. And some institutions will necessarily have higher proportions of waivers because of the kind of research that they are doing, particularly pediatric biobanking research. So the proportion of waivers or requests and granting of waivers should not be factoring into the analysis here, and the focus on rare or extremely rare misses the point. If there are criteria for when waivers should be granted and somebody meets the criteria, the waiver should be granted. So our takeaways for this little chat are that IU's standard operating procedure for reconsent is in line with federal guidelines. It matches the frequently asked questions site. The way they've got it set up is perfectly acceptable, but that the federal guidelines themselves do not adequately address issues unique to pediatric biobanking, and the emphasis on rarity of waivers misses the point. We should be refocusing on the appropriateness of waivers, the practicability of reconsent, and whether or not it will be detrimental to established, meaningful research.
Outstanding.
25 minutes.
Outstanding. I will open the floor to our in-person Representatives, I think some of you heard on our taping, it won't be on the tape, but if you're live with us, before we started today, we were chatting about a few things, including hopefully by the next talk, having first of all a better picture of the speaker's face, because I think our pictures now are from the end of the room, and more importantly, an opportunity for people who are watching to be able to call in and ask questions, or maybe even send in questions. When we post this, also we'll look for an opportunity for people to send in comments, questions we can respond to through the BSAP program. So, do we have any questions here? I mean, I'm looking directly at Mary Ott, who's our local expert on this topic before we got involved in this particular round, and she's involved in this investigation we've been underway. Any thoughts or questions, Mary? Mary says, thanks a lot.
So it's very interesting that the out is this practicability that you from a regulatory perspective. And so what we really need is thoughtful ethical guidance around practicability and what are the limits of practicability, what's allowed under practicability. It's sort of like this perfect ethics term where everybody sort of knows what it means, but no one can put a a clear definition to it. So I don't know. So if you could tell us your thinking about how should we IRB be going forward in terms of assessing practicability? What would make things practicable, and where would you put limits on it?
Well, I think there's a tendency for people to confuse practicability with impossibility. And so we don't want to be suggesting that the standard for researchers would be that they don't have to obtain reconsent, or in order to avoid obtaining reconsent, they have to prove that it would be impossible to do it. I guess a sort of 5-year-old term of practicability would be really, really, really hard to do.
There are parents in this room who know the intent in which how intensive that claim can be, that it's just really hard.
Yeah, I think 13-year-olds use the same technical term.
I'm sorry to hear they didn't grow out of that.
But I think it's also, we can look, I don't want to, rely on cliches or whatever, but it does tend to be, I would think, particularly from the IRB standpoint of you know it when you see it, that whether the person is really trying to skirt around the waiver issue by suggesting that, it's going to be really hard because our copier's down, versus somebody who's saying, I have 15,000 participants in this study. I got all of their consent, 2 years ago when they were 14, 15, and 16 years old, and you want me to go through that entire same process now. It will, increase the cost of my research outside of the budget for the research. I'd have to cut the sample size in half, that sort of thing.
Can you go back to the slide on waivers? That was a great slide. And by the way, any of these slides that are hard to read right now, for people watching, we'll probably have a corrected
PDF,
or
yeah.
PDF as well.
Oh, where is it?
Forward. Here it is. We go back.
Here.
Yeah, so the waiver, so it's interesting, in practicability, I think the history, I'm not an expert on this, Eric used to talk about our former director of the BSAP program and of the Center for Bioethics, who was basically around at the, HHS when they were coming up with practicability, I believe, or shortly after they come up with this idea as they formulated some of these regulations. And, he emphasized in that reminiscence that it had been, a term that they needed a concept of this, really, really difficult, because they couldn't require it impossible. But interesting, since we have the luxury of being the ethics people, it's interesting, the impracticability excuse is only available if there are not any, important violations of people's rights or putting people at great harm. Yeah. And so you might say, well, as long as there aren't such violations of people's rights or harms, why should there be any standard here? I mean, isn't a low standard sort of appropriate, given we've already included the requirement that, there's
minimal risk to the participant.
Right.
The waiver will not adversely affect the rights of the participant and the research, but practicability is actually part of those prongs. I'm not sure it's in this slide.
Yeah, that's okay. I mean, I'm just thinking this through that, I guess it's almost I can't really describe it in words, but it's almost an inverse relationship. As the danger and harm to the participants goes up, the standards for practicability could go up. for impracticability could go up. And I don't think it's in the regulations, but it's almost, if you think through this ethically, the excuse saying, really, I can't do this. Please let me do this research, even though I can't do this particular act, maybe reconsent. Yeah. It's important enough, and it's going to be bad, it's of limited harm to my participants, and the scientific outcomes are important. By the way, that is introduced a third factor, which is not, I guess, in here, which is how important is the research, which is, again, very, very hard to assess on a basis.
Everybody thinks their research is very, very important.
We do.
The other thing I think that's interesting, and I didn't include it in here, but probably should have, is that a lot of the things that we would think of as being, a lot of the things that make reconsent sort of silly. So, if you consented somebody at 16 or 17 and we think they're relatively mature and we should not have to go through that whole process again just because they turned 18, that profile of the maturity of the participant and their sort of psychological, that stuff is part of the initial consent consideration. So obtaining their assent to the research, that framework is contained in there. And so if they pass that first threshold of being somebody that has a responsibility to assent in the research, then revisiting it makes even less sense after age 18.
Okay. Fascinating. I was going to say, in terms of the take-home points, we do think of multiple audiences for this. We have some people certainly watching this now or in the future who have a more of an ethics background, who may have enjoyed our practicability discussion there, and certainly that's a continuing area of interest for the BSAP program and the Center for Bioethics, especially as we think about biobank research and other areas of precision health research. But for people who are researchers, I guess, who are just designing a biobank involving pediatric subjects, maybe another way I would summarize your point, maybe overly simply, is these are the regulations, you have to abide by them, but if the reconsent will be incredibly burdensome, think about applying for a waiver. Because at least as it stands now, waivers are a place to go to make that case, and the IRB has the freedom to. Now, of course, if this is recorded and played later, after we'll have to take it off the web, if the new common rule comes through with significant changes in this, we'll put an addendum on, or maybe have to do the talk again with the new common rule.
Extremely rare.
For those who do not have much of a background in regulation or ethics who are listening to this talk, there's a common rule changes that are being considered at this point. It looks like, I guess as time passes, we may not see it passed before the end of the administration. And so we may or may not see these changes.
Which is sort of good and bad. I mean, that we miss an opportunity with the new rule to include a reconsent provision that's workable. Although, how much faith do we have that the reconsent provision will be workable based on what it is as proposed now? Like, maybe not a lot.
Right.
On the practicability issue, the other things that I would throw out for investigators would be thinking about whether the reconsent changes the science. You could imagine that if you're doing research on a sensitive topic, I had a colleague who did research with adolescents on fertility preservation in oncology, and you could imagine that that at reconsent there may be some issues. There are certain types of people that may be more or less likely to reconsent. Yes. So there might be types of participants. Some participants are more difficult to find. There would be biases in it, particularly lower income families may be more difficult to track because they have more frequent moves. You may think about how ill the participants are the first time they were consented, because while a 16, 17-year-old should be able to consent, if it's an oncology biobank and they're consented at diagnosis and they're very sick, it may be better to just reconsent them after they're better. You know what I mean? Yeah. Like, it may not be the 18 rule, but there may be sort of how how consent was done in the first place. Does it change? Are there going to be biases in terms of you're able to maintain in the sample? The types of ongoing access would be, when do they download and link it to the EMR? So it feels like there's sort of pieces to it that may be relevant to this idea of like how practical is it, in addition to cost and burden.
Well, and the reconsent issue too becomes a problem because if we require reconsent and can't get it, if we're really sort of draconian about it, you have to have it to continue, then what is really the requirement for how the sample is handled or the information or the data is handled if you can't get it, which I didn't even include because it's such a messy conversation, but then do you have to pull that data out of your study, the data you've acquired up to that point? The rule as it exists actually says, it suggests you don't, but I mean, what do you do in those situations where you might have somebody who says, no, I don't reconsent, and I don't want my information being used as part of this research study, particularly like maybe in behavioral research, where somebody says, I'm thrilled that you've done this marshmallow study to see whether kids who can, not eat the marshmallow will be high-functioning adults, but I don't want people to know that I was the kid who ate the marshmallow in the first 15 seconds that was in front of me. Being light about it, but there's obviously more significant research than that. I love the marshmallow studies.
It's an authentic study, and we are sorry to tease those who are listening who don't know it. But if you want to Google Radiolab, which recently did a show which discussed it about it's Radiolab on the topic of fate and what fate means, and whether you can identify an individual's fate by identifying they have low self-control, such as myself. Okay, so wait, I want to also take this a little broader. So as we think about the reconsent issue, as you correctly, I think, really well pointed out in this talk, which I really appreciate, I think we all should appreciate and learn from, that this is related to the question of consent for biobank studies, and of course a debate which has been going on for a long time over whether blanket consent, sort of a one-time consent, is ever appropriate in a biobank. And I think my sense of the literature and the practice is that it is generally accepted now, which then leaves sort of as a last lingering question whether at least the transition from pediatric to adulthood would be a reason for reconsenting. If we're giving up on reconsenting in many cases, adults who've consented once. Do you have any thoughts on that, sort of how that's linked to those debates?
You get to kind of the layers there, and the layers of issues. So a blanket consent, you can imagine, makes sense for research that might change or samples that might be used for more than one kind of research. And so adding the vulnerable population of a child to that, it does make it slightly more difficult. I have a feeling that many adults, when they sign a blanket consent, cannot even conceive of all of the different ways in which that sample could be used for research. And so then you have an adult consenting on behalf of a child. So it's just the layers. It does make it more difficult. I mean, I'm very pro research, as I have said to you guys before, that I think we should be looking for ways that we can ethically facilitate research, not ways that we can identify ethical problems and shut research down. So, but certainly the layers, the more layers you have of analysis and issue there, the more complicated it gets.
I wonder if with this talk, I wonder if we could do this. I wonder if we could also put up, probably not at the same time, but the literature on actual harms to people participating in biobank research. I wonder what is there in terms of whether there are any documented cases of individual harm from participating in a biobank. Now, you can say there are dignitary harms, always, independent of any provable or recognized direct harms. So the harm of having a research done. Now, I suppose some of the great court cases around some of these biobank research such as the Hartsock tribe, I guess successfully brought a complaint over the use of their data in a way that was related to dignitary harm, I would say. It's probably worth looking into, and for those who would make a claim about maybe a request for a waiver, maybe we should make some of this harm literature if there is any available. We could talk about that. I shouldn't make work for ourselves, but it's an exciting area. Both, maybe we're getting close to the end here, but I'll say that as the BSTOP program is trying very hard as IU moves into this precision health initiative now, and some aggressive and innovative attempts to construct cohorts and do expand biobank research here, really getting clear on what is known and maybe some of the cutting edge ethics issues here is probably a good idea for us to do. So
I like that sort of next steps.
Next steps is good. Okay, so I guess that's it. Unless Tom, do you have anything? I didn't put you on the spot because you're a graduate student, so you get away with anonymity if you'd like. Okay. Anything else, Mary? Anything else? No, we're good. Okay, we're all good. So thanks a lot, Jane, and we're going to go ahead and wrap it up. Again, actually, those who are listening, before we even post this, if you have questions you didn't get to ask because we did not activate that functionality, please feel free to email me or Jane or the BSAP program, all available on the web. So Peter Schwartz at the IU Center for Bioethics, Jane Hartsock. You can contact us through the IU Center for Bioethics or through IUPUI. And have a great day.
Thank you very much, everybody.